Permit me to open this session entitled the Eurasian Economic Union Treaty, a new page of integration. The Russian Minister of Justice, Alexander Konovalov, is addressing our session. Dear participants in the conference, permit me on behalf of the organizing committee of the 4th St. Petersburg International Legal Forum to welcome you all here at this forum, which is viewed by the organizers as exceptionally promising and important. At the first forum, which took place 4 years ago, we said openly that we considered the possibility of assuring access for lawyers and other professions interested in contacting representatives of the post-Soviet Union, former Soviet Union state BRICS, East Asia and Africa, to build bridges, and Russia has always been such a bridge between worlds and civilization, because it has set a unique example of a very comfortable and friendly coexistence of most variable ethnic community and civilizations, because 150 peoples and ethnic groups live together in this country. So continued contacts between the East and the West, between the Anglo-Saxon system of law and the continental system, are very promising areas of development through the St. Petersburg Legal Forum, which and may become its exclusive brand. And we are thankful to all those who have agreed to take part in this conference, because what we consider as one of the first stages is contacts with the ex-Soviet Union space. One of such new areas of cooperation, a new challenge and a new phase of integration, is the Eurasian Economic Union, and it will require lawyers to work hard and competently. Both the customs union and the uniform economic and the single economic space and other formats that have taken place in the history of the former Soviet Union area have accumulated a number of practices and standards, most of them uniform, but it is no secret that the Eurasian Economic Union is a higher phase of integration and interaction, and it will incorporate standards already established at the level of the customs union and the economic space in a new integration format, with the need to fill the gaps that have become more apparent. But our ambitions go still further. This year, an award has been instituted for lawyers who have made the greatest contribution to this integration processes, and we believe that this award and the format of the conference you are going to hold now may go still further and access a larger scale of regional integration. Could be Shanghai Cooperation Organization or the BRICS or other interaction fora. So we believe this to be very promising. So from the bottom of my heart, I would like to wish every success to the organizers, speakers, and all participants. Thank you. Thank you, Alexander Ivanovich. I'm sorry, Vladimir Ivanovich. Permit me now to open our conference. We do not have a specific format. I think we'll give 10 or mostly 15 minutes to every speaker, and then we'll take 2 or 3 questions from the audience, depending on the interest taken by the participants. And in conclusion of this conference, we'll also have a floor discussion and hear experts and colleagues speak, so that we could come up with some approaches to what we call the Treaty on the Eurasian Economic Union. Of course, it's a new leaf. It's a new step in the legal regulation of the integration process, because the transition period from the Eurasian Economic Community to the Eurasian Economic Union through the Customs Union and the single economic space completes another phase of transition to a more regulated integration. So I think the treaty covers all kinds of all spheres of relations among nations, and this is also food for thought for academics, because the treaty itself incorporates certain concepts that require additional analysis, and it may be an interesting or maybe even an exciting discussion today. Representatives of all the future members of this union are present here, so permit me now to give the floor to Elvira Azimova, Deputy Minister of Justice of the Republic of Kazakhstan. Dear ladies and gentlemen, dear members of the conference, as regards economic integration, this issue is a new page of economic integration, but to be more precise, it's not quite new, it's another phase, another step. And I would like to say that the treaty signed in Astana on May 29th is a logical extension of the initiatives declared by our heads of state, and fills with specific content our economic obligations under the Eurasian Economic Space and the Customs Union. This treaty is not a new document, it's an optimized form of the contractual obligations that are stated in over 63 international treaties and agreements as part of the Eurasian Economic Community. Talking of the lawyer's role in economic integration, of course, it's very important. It's like the debate about what was first, the egg or the chicken. And of course, all the discussions that took place in the first phase of the development of the treaty could not have been held without the lawyers' participation. So we have set the task of deepening the economic objectives that we have set before ourselves, Kazakhstan included, as we access to the World Trade Organization. Of course, ready-made recipes for the resolution of economic issues cannot be given. This has to do with intellectual property, among other things. One of the sessions is dedicated to this issue. It's closely interrelated with economic relations, and for the Ministry of Justice of Kazakhstan. It is one of the tasks to protect intellectual property, and it has to do with parallel or gray imports. This is not an issue that can be dealt with easily, and the positions of different ministers differ. So far, we do not have common ground, but this is something that we need to form in the short term. And as the Justice Minister of the Russian Federation has said, the role of justice ministries is also to create a venue for ongoing dialogue, and the initiatives started by the Russian side has to do with the establishment of such a regular venue with the involvement of both justice ministries and corporate lawyers and economists. So considering that our primary objective, our paramount objective, are economic issues, we need to go beyond the purely legal scope of discussion, but to enter into a closer partnership with economists and financiers. And talking of the treaty as a whole, we have a lot of work in front of us. The treaty requires the development of clear mechanisms based on 120 decisions taken by the union's authorities and over 27 international treaties. Of course, we cannot be certain about everything in every detail, but we need to create a comfortable legal environment for implementing economic initiatives. Apart from the institutional venue, we are faced with the issue of lawyer training. One of the areas of the treaty is recognition of educational and academic degrees. This is incorporated in one of the sections of the treaty on labor migration, and something that applies to us directly are issues of the legal market. Here we see a whole front line for further work, and we hope our initiatives will be implemented. Another thing to concentrate on is the accessibility of decisions by the supranational body, the Eurasian Economic Commission. So the difference between the Treaty on the Union and the earlier regulatory framework is that the entrepreneurial sector will be more involved more closely in this process of decision-making through its involvement in the development of draft decisions to be taken by this authority. Right before the conference, the Council of Ministers of Justice of the Commonwealth of Independent States held a session to discuss, among other things, electronic forms of legal services. The treaty opens up new opportunities as an official source of law. And the website of the Eurasian Economic Commission will be used for that, to make the mechanism transparent and accessible not only for entrepreneurs or businesses, but also for citizens, because most economic issues will affect them. The next issue is that of international treaties to be concluded, which we have discussed.
And the possibility of signing international treaties by the nations as represented by the union bodies. And we need to address one of the issues relating to the classical principle of sovereignty and territorial integrity of the countries, because to a certain degree there's a lack of understanding of all parties concerned in the development of this treaty, how exactly the provisions, contractual agreements should be made about this by the member states. Another issue that we are going to actively address in the near future is the finalization of the legal basis of the future court of the Union. We have the court of the Eurasian Economic Council and the Economic Court. Still, we think that that should be a more active platform that should be different from the existing international judiciary bodies in the post-Soviet space. It should be closer and able to work faster when it comes to dispute resolution between the economic agents, which is not the case with the existing judicial bodies. Also, for the first time, we provide for an institution of specialist experts which should be an active instrument to be used by the judges in court. I've mentioned the key things that we have established for ourselves, and importantly, it is important that this dialogue continues so that we come to the consensus based on this conference, and this dialogue will be an ongoing dialogue on a wider basis. Thank you. It was a good presentation. Why don't we applaud? Thank you, Elvira Hasipovna. I promise to take a couple of questions, then we can move on. I don't see too many. Are experts allowed to ask questions? I have a question. There are many substantial topics that were touched upon by the first speaker in terms of the improving of the legal framework at the supranational level. Are there any plans to use the method already known in Russia to assess the regulatory impact? We discussed the involvement of businesses and external experts in the drafting of the respective acts, and of course the practice already accumulated in Kazakhstan and Russia. Will it be used and to what extent for the union level? Thank you for your question. That is indeed a very good mechanism that every member state has developed, and it is already secured in the Treaty on the Eurasian Economic Treaty, the regulatory impact assessment. Without businesses or corporate lawyers, it would not be fruitful enough. I think that should be quite an active platform, with initiative coming not only from the governments but also from businesses. Any more questions from the floor? Okay, then our next speaker is Igor Tushinsky, Deputy Minister of Justice, Republic of Belarus. Thank you. The title of my talk is the Belarus view of the of this Union Treaty. I appreciate the kind invitation to speak here, and I thank the organizers. We called it that treaty so often, referred to the treaty so often as the draft. I'm not used to calling it the treaty. It's the institutional component, the close, and the functional components. The functional part defines the legal jurisdiction of the economic union of the three states, and the provisions of the treaty characterized this as a regional economic integration organization in the classic sense, which opens new opportunities for wider collaboration with other countries while avoiding doubts or concerns about the legal nature of the union. The institutional component defines the principles and guidelines of its existence. The leading bodies include the Higher Eurasian Economic Council, the Eurasian Intergovernmental Council, the Eurasian Economic Council, and the Court of the Eurasian Union. The Supreme Council is the higher body of the Union. That's the way we experts call it briefly. That's the high level of the body. Sitting on it are heads of the member states that considers the essential matters, key matters for the sake of integration. The Intergovernmental Council is the body constituting is to coordinate and implement the agreements as part of the Union. To implement the decisions of the previous two councils, maybe some other documents may need to be adopted to regulate the procedural things. We in Belarus, for instance, already realized that we would need to adopt an internal regulation to regulate the preparation and implementation of the both Supreme Councils. I suppose our other two states would prefer to do the same. The Commission, as established in 2011, is an ongoing board. The Permanent Court is the driving factor of success of the Union and legality of its bodies. The activity of the Court is for uniform enforcement of the international union, international laws within and without the Union, and the treaty also provides for the opportunities to create auxiliary bodies in individual lines of activity with involving many national bodies to draft decisions as part of the Union. All decisions, except those of the Court, will be normative, and the decisions of the two Supreme Councils will be implemented as specified by the national legislations. Also, there is a mechanism for decision-making by the Union bodies. The two Supreme bodies and the Commission have to be made by consensus, and the collegiates will be made by the majority and by the consensus in case of sensitive issues, with procedures to challenging or appealing against the decisions by bringing them higher. The Belarus party, back in the autumn of 2012, developed and submitted to the partners, sent to the partners, to the Union, the concept of the normative and organizational regulation of the Union. The key approaches in the concept have been included in the institutional component of the treaty. The functional component is a totality of international treaties as concluded by the three states as part of the customs union and the single economic space, and some treaties that are valid within the Eurasian Economic Community. The institutional part features Article 6, the law of the Union. For the first time in the Eurasian development, there is a clear hierarchy of the acts of the Union, with two tiers or two branches: international treaties and acts of the bodies of the Union. The Underlying this is the Treaty of the Eurasian Economic Treaty and all international treaties to be concluded or to be concluded, and international treaties within the Union, between the Union and third countries shall be in compliance with the basic treaties in the Union. Underlying the hierarchy of the acts of the bodies of the Union are the decisions of the Supreme Council, the decision of the Intergovernmental Council, compliant with the former, and acts of the Commission shall be compliant with the acts of the above-mentioned two bodies. Acts of the bodies of the Union shall be compliant with the Treaty on the Eurasian Economic Union. This is the hierarchy of legal acts. For the first time in the practice of this Eurasian integration process, this possibility has been implemented. The Belarus party has always put forth the need to specify the description of the limits of competence between the Union and the member states, because we understand how important it is to objectively secure in the institutional part the division of competence and the mechanisms to have it implemented. We understand that this matter is one of the principal things on which we are still not in agreement, because the division of competence is the most sensitive and delicate issue in any such union, and Article 5 of the treaty saw the most of debate. Simple enlisting of the competences of the Union or joint competences would not be enough because of its overall framework character. None of the exclusive competence of the Union will not be covered by the Union fully. There will be some space subject to regulation by the national states, member states. The division of competence of the Union and the member states is of special importance in conjunction with other matters, such as who exactly, the member states or the Union, on which issues, subject matters, or on what format shall make mandatory decisions. The answers to these questions would allow to exclude subjectivism in decision-making. For that, Belarus has suggested a sequence of forms: competence, then the type of policy to be implemented, and the body and the format for the policy to implement. One example of exclusive competence of the Union could be, for instance, in customs and tariff regulation. There should be a single policy in place, and its results should be finalized by the Supreme Council decisions. The logic is quite clear in our view. Also, the Belarus part, based on the functional component of the treaty, would define the exclusive competence of the Union and joint competence. We have made a thorough analysis and presented it to our partners on the functional part. However, during the discussion of joint competences, there were unexpected difficulties in our view. Our partners never achieved the consensus as to what kind of joint competences to be fulfilled. The joint competence of the Union and the member states, the way it is done in the European Union, or the joint competence of the member states achieved for the sake of fulfilling the goals of the Union. Belarus suggested the respective wording for both cases. However, none of our propositions have been adopted. As a result, Article 5 of the treaty, the way it stands today, looks incomplete, I think, because it is vague, because it is not very clear what it falls within the terms of reference of the Union or individual competence of the member state or all member states together. That uncertainty must be eliminated, and I will call on our member state partners to sit down and negotiate and agree on that. Thank you for your time. Thank you, Igor Geraninovich. Any questions from the floor? Well, everything looks quiet. Maybe we receive more questions as we go, because interesting topics have been raised, and of course they could be interpreted differently. And I'm giving the floor to our next speaker, Viktor Leonidovich Yevtukhov, Deputy Minister of Industry and Trade of the Russian Federation. Good afternoon, dear colleagues. I didn't hear any information about the time limit, so maybe I've prepared too many talking points. But fortunately for myself, the previous speaker has undertaken part of them himself, so I'm going to highlight just the balance, maybe some more less exciting things that still will be discussed for days and weeks. The treaty, its components, functional and institutional components, and closing provisions. I'll try to be brief as I look at the room. It's a pleasure to see so many people in the room, because I see a good half of the room are witnesses of the developments after the collapse of the big country, the Soviet Union. A whole lot of problems emerged, self-identification and trying to select the way to develop further. And maybe we should recall once again, back in 1994, President Nazarbayev, he spoke at the Moscow State University, expressed for the first time the idea of Eurasian integration. You would agree with me, wouldn't you, that the true understanding of the essential need to build the Eurasian space came much later, when the leaders of the three countries, Russia, Kazakhstan and Belarus, saw the Eurasian integration as not just a counterpoint to the global giants, but to create a geopolitical axis from Lisbon to Vladivostok. And of course, the integration started with a customs union to provide free flow of goods between the three states, but then integration went beyond trade relations, and the signing of the Eurasian Economic Union Treaty actually meant the achieving of a new frontier for the coordination of the economic and industrial policies, something that we had strived for years. A huge work has been done, and those of you who are not aware of that, let me reveal this. Everybody's secret, that the treaty has been the result of codification of 63 international treaties underlying the legal framework of the treaty. It includes 118 articles broken into 28 sections. The treaty has more than 30 addenda. These figures may not be that exciting, but the order of magnitude of the figures shows a huge work that went into the drafting of it and finalization of it. And it was more than just legal coordination. It took a lot of disputes at the level of experts and working groups, and the Council of the Eurasian Economic Committee itself, and of course the Supreme Councils, the numerous Supreme Councils there. There's been an obvious success of economic integration that provided the civilization basis of the Eurasian approach. I'm recalling the philosophical and political approach that went against global integration of Russia in favor of integration with Central Asian states. Maybe some people have heard or read about that. And for some others, that could come as a news, but according to Eurasianism, Eurasia is a world that is geographically different from nations west of it or east or southeast of it alike. So the great Russian academic Lev Gumilov once wrote that Russia slash Eurasia, located in the middle of the continent of the old world, has much more reason to be called the Middle Empire than China, or much more reason than Germany to be called the middle of the, because the middle is the West Europe, and the Russia is the center of the old world.
Центр.
And if you remove this center, this system of continent margins turns into ruins. But after the collapse of the Soviet Union, Russia's road was not a simple one. We had to choose between becoming another form of Europe or becoming a third Rome and promote its theocratic ideas, or to concentrate on the Eurasian approach. And the choice in favor of the Eurasian Economic Union was not only dictated by economic interests, but also by a common historical heritage, by geopolitical interests, and by the sets of values that our nations have historically. We know that the West has viewed the idea of a Eurasian Economic Union in different ways. It is really inconvenient for the unipolar model of the world supported on both sides of the Atlantic, because this is something done outside their worldview or without their influence. And quite recently, we have had St. Petersburg Economic Forum, where our president, Mr. Putin, said politics affected economic processes, and that the inability to compromise creates many risks. That's why business is incurring losses because of inconsistent policies. So as an alternative to those negative tendencies on both sides of the Atlantic, he believed the Eurasian Union was one such alternative. And I'm not going to go deep into the details of the Eurasian Economic Union, but from the perspective of the Ministry of Commerce and Trade, which I represent, I would like to discuss the points which triggered the very serious debates and discussions continuing right until the signing of the treaty itself. Primarily, the fact that uniform rules of industrial subsidies were recorded in the treaty. Our negotiations were really hard. Voluntarily, members of the Eurasian Economic Union can apply for specific subsidies to the Eurasian Economic Commission, and the other members cannot use compensatory measures in reply to that. That is, common agreement is necessary for such subsidies, and generally subsidies received a lot of attention from our countries and agencies. So the decision was that whereas previously one had to operate technologically within one's national borders to get a subsidy, now this operation is possible also in the territories of other Economic Union members. That was done to encourage more cooperation ties and industrial integration as a whole. In addition, I would like to say that the list of exemptions was expanded for members of the Economic Union to give subsidies without fear of complaints from other members. And here I mean subsidies to car assembly factories. We know that in Russia our required localization level is at least 50%, but we met the interests of our partners halfway, Belarus primarily, and we allowed and we made it possible for them to allow for longer terms of localization and a different percentage. The freedom of the free movement of goods is one of the four freedoms used as the principle of the integration, and the parties agreed on new technical regulation standards. It was the object of a broad debate, including construction processes, and we were able to find common ground in the final phase of our negotiations. And I also must mention that the Union Treaty requires a harmonization of the national legislations in terms of oversight over observance of technical regulations. Harmonization of regulatory requirements and technical regulations is always necessary. We know that if we cannot regulate the movement of goods using customs mechanisms, then technical mechanisms can be used, and this is very important. Another point I'd like to make. During our negotiations with the Republic of Kazakhstan and the Republic of Belarus, we were able to include a new provision in the final version of the treaty to support domestic manufacturers in the course of investigations against dumping and compensations, and Elvira Azimova will confirm that we've had a very active discussion with Kazakhstan to include the notion of retroactive recourse measures. Let me give you an example. When some investigations were launched, importers tried to import as many goods as possible before new import duties were imposed, and we arranged it that every importer should know that if such a measure is adopted, it will be applicable from the start of the beginning of investigation. We were able to introduce new terms for the introduction of new or special duties. A special duty will take some 6 months, and the anti-dumping duty is 7 months. We also reduced by about 50 days the required terms for initial procedures, something mentioned by many industrial unions and associations, which asked us to bring those periods or time limits to the maximum, because that would really threaten our markets and created opportunities for wrong policies to harm whole industries. I could go on for a long time discussing the points which we compromised on after a long dispute, but we can say that we have been successful because new countries are trying to join the Union. You know that we are now in active negotiations with Armenia and now Kyrgyz. The Kyrgyz Republic is willing to join. And I would like to conclude by citing Mr. Putin, who said a new economic organization has emerged on the international sea, which has full international jurisdiction. Thank you very much. Are there any questions from the floor? You have told us so much about Section 24, which is okay. But I have this question. Will there be any harmonization of industrial policy legislations? As far as I understand, a bill has been developed and is to be adopted shortly. Well, industrial policy was synchronized, and that was the object of all our negotiations. And now we have drafted a very a very consistent and well-received regulation on industrial policy. Of course, it was based on the treaty, but with added opportunities that we have to develop our own industry and all our sectors, which we're going to support within our obligations. We have assumed and using all the permitted mechanisms. I hope it will be considered by the State Duma shortly and become a law that many have been waiting for such a long time. More questions? No questions. Now we are to have a coffee break, and I don't think we can. There's a point in giving the floor to another speaker, Ms. Neshataeva. You'll speak after the coffee break. So now a break for 15 minutes.